He called me sweetheart and explained the law like it was a children's book. He had no idea the woman he was condescending to was about to dismantle his entire career. The air in the deposition room was thick with the scent of old paper and overpriced cologne. My boss, Mr. Davies, a good man with fraying nerves, kept adjusting his tie. Across the massive mahogany table sat our adversary, Preston Vance III, a man who looked like he was born in a three-piece suit. He was the lead counsel for a tech giant trying to steamroll our smaller client, and he oozed the kind of smug, effortless confidence that only comes from a lifetime of never being told no. I was sitting just to the right and slightly behind Mr. Davies, tasked with taking notes. To Preston Vance, I was part of the furniture, a decorative, diversity hire piece of furniture. He hadn't addressed a single word to me directly for the first 2 hours, but his eyes would occasionally flicker my way when he was explaining a particularly complex point. It was always followed by a condescending little smirk, a non-verbal, "I'm sure this is all going way over your pretty little head." I just kept my face neutral, my pen gliding silently across my legal pad, my expression as placid as a lake. But beneath the surface, a fire was building. He had no idea who I was, where I came from, or what I was capable of. He saw my dark skin, my neat braids, my gender, and his brain, programmed by generations of privilege, filled in all the blanks with stereotypes. To him, I was a token, here to make the firm look progressive. "Now," Preston began, leaning forward and steepling his fingers, "let's discuss the interpretation of the non-obviousness clause in this patent. I want to make sure everyone is on the same page, as it can be conceptually challenging." His gaze landed on me, and he gave me a slow, patronizing smile. "Think of it like this, sweetheart. Imagine you have a toaster, and you have a radio. It might seem like a clever new invention to put them together, but the law asks, would a person of ordinary skill, say a regular appliance designer, find that combination obvious? It's a simple test, really." I could feel Mr. Davies shift uncomfortably beside me. He knew I wasn't just a paralegal. He knew I was the one who had found the linchpin for our entire defense strategy. But he was also a man who avoided confrontation at all costs. Preston Vance was a shark, and Mr. Davies was just trying not to bleed in the water. I, however, had been swimming with sharks my entire life. "Our argument," Preston continued, his voice booming with unearned authority, "is that the technology our client developed, while superficially similar to your client's patent, is a quantum leap forward. It's not a toaster radio. It's a teleportation device. The precedents are crystal clear on this matter, stretching all the way back to Graham vs. John Deere Co." He gestured grandly to a stack of binders. His own junior associate, a nervous-looking young man who wouldn't meet my eye, had arranged. "My team has prepared a comprehensive brief outlining every single case that supports our position. It's airtight. Frankly, I'm surprised this has even gone this far. Your firm should have advised your client to accept our initial and very generous settlement offer." He sat back, the very picture of victory, crossing one immaculately tailored leg over the other. The room fell silent. Mr. Davies let out a slow, defeated sigh and began shuffling through his own papers, looking for a rebuttal he clearly didn't have. The weight of Preston's arrogance was pressing down on all of us, suffocating the hope in the room. He believed he had already won. He thought he was the smartest person at this table by a factor of 10, and that was his first mistake. My pen had stopped moving a few minutes ago, not because I was intimidated, but because I was waiting. I had listened to him build his entire argument, brick by smug brick, and I had spotted the flaw. It wasn't just a crack in the foundation. It was a stick of dynamite with a lit fuse. He had built his entire teleportation device argument on a specific interpretation of a recent circuit court ruling, a ruling he had quoted with immense confidence. But he hadn't just misinterpreted it. He had apparently missed the final amended judgment that was published 2 weeks ago, a judgment that completely inverted the precedent he was leaning on. I knew because I had written the winning amicus brief for that case as a research fellow. My heart hammered in my chest, a drumbeat of anticipation. This was the moment. Preston Vance picked up a glass of water, preparing to deliver what he clearly thought would be the final, crushing blow to our case. He opened his mouth to speak, but before a single sound could come out, I did something I hadn't done all morning. I cleared my throat. It wasn't a loud noise, just a soft, polite sound, but in the dead silence of that room, it echoed like a gunshot. 7 heads swiveled in my direction. Preston's eyes narrowed, his condescending smile faltering for the first time, replaced by a flicker of pure annoyance. "Is there a problem?" he sneered. "Did you run out of ink?" A slow smile touched my lips, but I kept my eyes on my notepad. "No, Mr. Vance," I said, my voice quiet but carrying clearly in the tense silence. "The ink is fine. I just wanted to spare you the embarrassment of building your entire argument on a foundation of sand." I finally lifted my gaze to meet his. The annoyance in his eyes curdled into disbelief, then into pure, unfiltered rage. His face, usually a mask of smug amusement, began to turn a blotchy red. "And who do you think you are?" he sputtered, his voice losing its polished baritone and rising in pitch. "The paralegal? You're here to take notes, not offer your uninformed opinions." Mr. Davies shot me a panicked look, but I gave him a slight, almost imperceptible shake of my head. "I've got this." I stood up slowly, smoothing the front of my blazer. I felt the eyes of everyone in the room on me, a mixture of shock from his side of the table and utter confusion from mine. "My name is Dr. Imani Hayes," I stated, my voice level and cold, "and my uninformed opinion is that your reliance on the initial ruling of the Ninth Circuit in Innovate Corp vs. Tech Solutions is, to use the correct legal term, malpractice." A collective gasp went through the room. The nervous junior associate across from me looked like he was about to faint. Preston Vance looked like he'd been slapped. "You have no idea what you're talking about," he snarled, but the bravado was gone. A tremor of uncertainty had crept into his voice. "On the contrary," I said, walking slowly to our side of the table, "I know exactly what I'm talking about. You are correct that the initial ruling supported a broad interpretation of obviousness. Your whole toaster radio versus teleportation device argument hinges on it." I paused, letting the words hang in the air. However, an amended judgment was issued 16 days ago. It was a full reversal, a per curiam decision, meaning the entire panel of judges agreed. It not only reversed the lower court's decision, but it explicitly narrowed the interpretation of obviousness, making it significantly harder to dismiss patents like my client's. I leaned forward, placing my hands on the mahogany table. I was looking directly at Preston now, and I saw the first glint of real fear in his eyes. He was scrambling, his mind racing, trying to find a foothold. That's an obscure amendment," he stammered. "A minor clarification." "It was hardly obscure, Mr. Vance. It was the talk of the intellectual property world," I said, my voice dropping to a near whisper, ensuring he had to strain to hear me. "It fundamentally changes the landscape, and your entire multi-million-dollar defense, the one you've spent the last 3 hours so condescendingly explaining, is now completely worthless." I straightened up. "You see, the reason I'm so familiar with the amended judgment in Innovate Corp vs. Tech Solutions is that I was the lead author on the amicus brief that the court cited in its reversal. My analysis was the foundation for their decision. The silence that followed was absolute. It was so complete I could hear the hum of the fluorescent lights above. Mr. Davis's jaw was literally hanging open. Preston Vance's face had gone from red to a pasty, sickly white. The smug mask had shattered, and behind it was just a scared, incompetent man who had been so blinded by his own prejudice that he hadn't bothered to do the most basic due diligence. He hadn't even bothered to Google the lawyer sitting across from him. He slammed his hand on the table, a desperate, pathetic attempt to regain control. "This meeting is over. We will reconvene when—" "I don't think so," I cut him off, my voice like steel. "We're not done here." I turned to the stenographer, whose fingers were flying to catch up. "Let the record show that opposing counsel has just admitted his entire legal strategy is based on an overturned precedent." I turned back to a pale, trembling Preston Vance. "And now that we're all clear on the actual state of the law, I think it's the perfect time to discuss Exhibit 7B, the email from your CEO, dated May 14th. The one you fought tooth and nail to claim is protected by attorney-client privilege based on your flawed legal theory." Preston Vance's eyes widened in sheer panic. Exhibit 7B, the email. It was the smoking gun we'd been trying to get admitted for months. In it, the CEO of his client's company practically confessed to reverse engineering our client's patented technology. But Vance had successfully buried it under a mountain of procedural objections, all tied to his now demolished legal argument. He knew, and I knew, that without that flawed argument to shield it, the email was not only admissible, it was catastrophic for his case. "That document is privileged," he insisted, his voice a reedy imitation of its former boom. "The new ruling, it doesn't change that." "Doesn't it?" I replied, raising a perfectly sculpted eyebrow. I walked back to my seat and picked up my own copy of the case file, flipping it open to the exact page I needed. The amended judgment in Innovate Corp specifically addresses the crime-fraud exception to privilege. It states, and I quote, "Privilege cannot be used as a shield to obscure clear and present evidence of intellectual property theft when the initial legal theory for such protection is found to be fundamentally unsound." The judges might as well have written that sentence with your client's name on it, Mr. Vance. Your entire claim of privilege just evaporated. I looked at Mr. Davies. The shock had finally faded from his face, replaced by a slow, dawning, brilliant grin. He looked like a man who had just been told he won the lottery. He cleared his throat, finding his voice at last. "Dr. Hayes is correct. We will be moving to compel the immediate unsealing of Exhibit 7B. Given its contents, I imagine your client will be very interested in revisiting our original settlement offer, perhaps with a few more zeros added on." The transformation in the room was electric. The oppressive weight of Vance's arrogance had vanished, replaced by the humming energy of our victory. His junior associate looked relieved, as if a great burden had been lifted. Our team was buzzing with suppressed excitement. Preston Vance, however, looked utterly broken. He slumped in his chair, all the air gone out of him. He had walked in here a titan of the industry, and in the space of 10 minutes, a woman he had dismissed as a glorified secretary had dismantled his career with a few quiet, well-aimed sentences. He didn't even try to argue. He just stared at the mahogany table, seeing the reflection of a beaten man. After a long, agonizing silence, he muttered, "We need to caucus." He and his team practically fled the room, leaving behind the scent of defeat and expensive, now sour cologne. Mr. Davies turned to me, his eyes shining. "Imani, that was incredible. Why didn't you tell me you wrote that brief?" I shrugged, a genuine smile finally breaking through my professional composure. "You hired me to find a winning strategy, sir. I found one. It wasn't about me. But of course, in that moment, it was a little bit about me. It was for every time someone had underestimated me, talked down to me, or assumed my abilities were limited by the color of my skin." Less than an hour later, they were back. Preston Vance didn't even sit down. He couldn't look me in the eye. He addressed Mr. Davies, his voice flat and lifeless. "My client has authorized me to accept your original settlement terms." Mr. Davies shook his head. "I'm afraid those terms are no longer on the table." He slid a piece of paper across the table. It was a new number, 3 times the original amount. "This is our new offer, plus a full public apology for the patent infringement. It's non-negotiable." Vance's lawyer looked at the number, winced, but nodded his defeat. The deal was done. As they packed their briefcases, defeated and silent, Preston Vance finally looked at me. There was no smugness left, no condescension. There was just a hollow, bewildered look in his eyes. He opened his mouth as if to say something, maybe an apology, maybe an excuse, but no words came out. He simply shook his head and walked away. As we left the building and stepped into the bright afternoon sun, Mr. Davies put a hand on my shoulder. "You know, Imani," he said, "I'm promoting you to senior partner, effective immediately. I don't think anyone will object." I laughed, a real joyful sound. It felt good. Not just because of the promotion or the win, but because today a man who saw me as nothing more than a decoration was forced to see me for who I truly am. Harvard's top legal mind. And it had cost him everything.